Hannah Welch-Levin. Thank you so much for attending today. This is the fifth in our series of webinars regarding what landlords need to know. And so I am a real estate attorney. I've been practicing real estate law in California for 15 years, and part of the practice is landlord services, and the rest of the practice is other kinds of real estate legal services, such as litigation, real estate fraud, easement and boundary line disputes, and a plethora of other things that we do. But we're really focusing on being a resource for landlords right now, and so that's why we've developed this series of webinars. So yeah, today's discussion is, the main focus of today's discussion is all of the new laws and all of the COVID-related issues that landlords need to know about right now and for 2020. And we want to make sure that landlords and property management companies don't experience more delay than is necessary due to the situation going on with COVID, and also that they don't have to deal with an uncomfortable situation if it's not necessary. So by uncomfortable, we mean financially or otherwise. There's a lot of discomfort in the landlord-tenant relationship right now. So we'll answer the questions of what are the biggest legal barriers to watch out for? How can you prepare in advance? What can you do right away to make sure that you can move forward when the state of California, the city of San Diego, or other local entity or government entity allow you to move forward with your legal rights as a landlord? So when this year started, I thought that the new rent cap and just cause eviction statute was going to be the hardest thing that we would be dealing with this year. And I still find that new law to be pretty significant and difficult. But what's become even more difficult to deal with is that right now and for the foreseeable future, we can't evict anyone due to the California eviction moratorium unless there is a public health and safety issue that allows us by court order to move forward. So let me provide you first with an update on the eviction moratorium and an estimated timeline. Actually, yeah, that's the slide. So the court did reopen on May 26th, and they are providing mostly virtual services, still no evictions. And in a hearing just yesterday, I was asking the court for a hearing date for a different kind of matter, for a civil matter. And the judge gave me a date of December 4th for the motion. And I said, Your Honor, that's our new trial date that we received. After the courts reopened, they gave us new trial dates, and that's our new trial date. And he was pretty jovial in stating that there's really no chance that you're going to trial on that date. There's no way we're having trials this year, as far as I know. That's what he was telling me. So we have this situation where we really can't move forward with these eviction cases until the court allows us to, and I'll explain more about why we can't move forward. But first of all, there are a lot of local eviction moratoria that relate to COVID rent deferment protection for tenants. Some of the local eviction moratoria ordinances prevent landlords from issuing notices to pay or quit. But in most of the scenarios that I've reviewed with landlords, I believe that the tenants have not complied with the local statutes, and so legally we can still issue notices to the tenants to pay rent or quit, or for other kinds of breaches of contract. So we are trying to encourage landlords to move forward if the tenants are not in compliance with the local ordinance. In the city of San Diego, the current local ordinance has recently been extended to September 30th, and that is because the governor's office indicated that they are extending their recommendation for these moratoria through September 30th. The San Diego ordinance applies to rent that was due on or after March 12, 2020, and in order for a tenant to claim their rent deferment, they have to provide written notification to the landlord that they have a COVID-related hardship on or before the due date of their rent. If they do so, then they have 1 week to provide further documentation supporting their hardship. And then if they deliver that to the landlord, then they do not have to pay their rent for the foreseeable future through September 30th. Initially, the statute stated that the rent would be due 6 months after the issuance of this ordinance. That date was September 25th, 2020. Now that the ordinance has been extended beyond September 25th, 2020, we have not received any guidance about when the rent would become due. The ordinance also said that the rent would become due upon termination of the executive order from the governor's office, which someone said, and I don't know where this comes from, that that was scheduled to expire, if it's not extended, on July 28th, 2020. I haven't seen that legal authority. So as far as I know, I'm relying on that 6-month provision, and also assuming that we'll get further guidance from the city council for the city of San Diego on when the tenant's rent will become due. They may also be relying on some of the legislation that's coming down through the state legislature that may trump the local ordinances. So in Chula Vista, they have extended their ordinance through July 31st. This is just based on what's on their website. They have virtually the same requirements as the city of San Diego, except that the rent is due no later than 6 months after the end of the eviction moratorium, but no later than December 31st, unless it's extended by another ordinance. So again, unclear, but probably tenants won't have to pay their rent in Chula Vista if they have a COVID-related hardship through the end of the year. In National City, I heard that they had voted to extend through August 31st, but when I looked at the city's website this morning, that had not been posted yet. So theirs was scheduled to expire June 30th. I assume that they did extend it. There is an indication in the news, but it's not officially on their website yet. Their ordinance is a little bit different because the tenant has to claim the rent deferment within a reasonable period of time of the rent due date, not to exceed 7 days. Renters also must provide the documentation after claiming that they can't pay the rent. They have to follow up with the documentation of their hardship within 30 days of the rent due date. So those are just some of the local ordinances. The county has its own ordinance for those unincorporated areas. Oceanside has its own ordinance, and there are hundreds of these throughout the state. The best way to locate those, I find, is through the California Apartment Association. On their website, they have links to most of the local websites where those ordinances are posted. What's really the overriding problem for landlords getting evictions through to the courts is the statewide eviction moratorium that was issued pursuant to the Judicial Council Emergency Rules of Court. So all of the moratoria that I just mentioned are less restrictive than what the Judicial Council did on April 6th. And almost all of those orders require a COVID-related hardship. The local ones require a COVID-related hardship, require tenants to show their hardship and documentation of the hardship. But these Judicial Council rules apply to all evictions, residential and commercial alike. There are no conditions related to COVID at all, no documentation or hardship required. They don't specifically relate to any type of eviction, such as a non-payment of rent or any specific type of breach of the lease. It applies to all evictions across the board. Rule number 1 of these Judicial Council rules states that a court may not issue a summons on a complaint for unlawful detainer unless the court finds in its discretion and on the record that the action is necessary to protect public health and safety. That means that when we file the eviction, what happens, let me tell you rule number 4, the second one that applies here, and then I'll explain what's happening when we file eviction. Pursuant to number 4, the rule remains in effect for 90 days after the governor declares that the state of emergency is lifted, or until the emergency rules are amended or repealed by the Judicial Council. And what we're seeing is the possibility of them being repealed at some point in the future, closer than 90 days after the governor declares that lifting the state of emergency. When we file an eviction, we file the complaint and all of the other paperwork, including a summons, and we are receiving the complaint back. We are receiving a case number, but the clerk is bouncing back the summons document unconformed, without any seal of approval, with a letter explaining the reasons why it's being kicked back. And the reasons are these Judicial Council rules. So what happened in June is that the Judicial Council made a recommendation to the legislature to vote on sunsetting this particular restriction, the restriction to not issue the summonses. And that was voted on June 10th, and it failed. So the proposal by the Judicial Council was to sunset the rules on August 3rd. It failed, so those rules are going to continue through August. And the best we can hope for is that a new proposal is made for September and the vote is favorable. So that caused us some concern about the timeline that we've been putting forth, because we were hoping that we'd be able to proceed by the end of August, and it just really looks like that's not happening. We would also expect a significant backlog when we are finally permitted to move these forward, because everybody who has filed evictions, and we've filed 4 or 5 at this point, will be trying to submit their summonses to the court at the same time, and the clerks are going to have to process those in whatever order they deem appropriate. So the timeline, what we would expect is if we're able to get our summons at the beginning of September, once we get it, we send the complaint and the summons out with our process server. Depending on how the process server finds the tenant, the defendant in the lawsuit, the defendant has between 5 and 15 days to respond to the lawsuit. Some tenants respond, some don't. If they respond, then the case is set for trial. If they don't respond, then we default them and we get a default judgment and do the lockout that way. These two roads, these two paths could be on similar timeframes because of court backlog. When you go to trial, you request to set the case for trial, and statutory law requires the court to schedule the trial within 20 days of the request. And then you get your judgment and your writ within a day or two, typically, unless there's some reason why the court takes extra time to process your judgment. On the default path, you submit a package of paperwork and you rely on the clerk to issue your judgment and issue your writ. And depending on their backlog, you know, these two roads could take about the same amount of time. We'll have to wait and see. We've seen the courts backed up weeks and weeks on these in the past just due to budget issues. Then once you get your judgment and your writ, you submit that to the sheriff's department, and the sheriff then has their own timeline. So that could be, you know, 10 days to 2 weeks. And when they're really backed up, that can take up to 4 weeks. They post a 5-day notice to vacate, and then they call us when they're ready to do the lockout. When you add all of these timeframes up, we would see trials hopefully mid-October to the end of October, and lockout sometime in November. That's if we can get started at the beginning of September, which, you know, we're a bit pessimistic about that timeline. So also there are lots of cases that were pending prior to the court shutdown in March that also haven't been able to move forward. The sheriff is not performing lockouts. We've got one case where we have a writ of possession. The sheriff has it in their hands, and they've scheduled that lockout twice and canceled it twice, and it still hasn't happened. That's for an eviction that was completed in early March. The killer question that I'm getting, and this is a tough question and it's outside of my pay grade, is whether all of these restrictions and all of the difficulties they're causing landlords could qualify as a taking under the United States Constitution or the California state constitution. The constitutions forbid the taking of private property for public use without just compensation. And the way we learn this concept in law school is that this is like an onion, where you have the first case that interprets this clause, and then you have the next case that interprets that previous case law, and a new issue comes up and there's another case. So we have a plethora of case law interpreting what is a taking, what is eminent domain, and how do you compensate people for it. But when you interpret what's going on right now, in my opinion, this is just my opinion, and again, above my pay grade, but you have a problem with the for public use part of the taking, because the government is not taking anything for public use. Also, the orders of the governor and of the local ordinances are pursuant to existing law relating to government police power. and they are in the interest of public safety. So they're not actually issuing new laws that are taking land away from people. They're just restricting use. There was a case law, I recall, that if the use was only partially restricted and left some other use, that's not a taking because there's still some small portion of the use. It's not 100% taking of the use of the land, so it's officially not a taking. It's also not a permanent taking because we do expect this to pass. We don't know when. And so the taking depends on the extent of the restriction. It only relates to land. It doesn't relate to restrictions on businesses, and there are other legal issues to be litigated relating to the harm that's being caused to businesses. So as I said, when 2020 started, I really thought that this new Tenant Protection Act of 2019, the rent cap and just cause eviction laws, were going to be the hardest part of my job. That's turned out not to be true, and unfortunately, I still find this law difficult to interpret and difficult to explain to people, but I'm going to try, and I'm going to try to do it quickly. So the new Tenant Protection Act added certain statutes to our civil code, and within these statutes, they only apply to some residential properties. The new statutes don't apply to commercial properties, and there are a number of other exemptions from the statute. So the first thing we need to do whenever a landlord or a property manager calls about this law is to determine whether the property we're talking about is exempt or not exempt. And the statute requires the landlord to claim the exemption, or if they're not exempt, they have to inform the tenants that the property is not exempt. So the way this goes is it's like a funnel. So first of all, most single-family residences and condos will be exempt from the statute unless they are owned by a corporation. And if they are owned by a corporation, then we have to look a little bit further into how the corporation is owned, because some corporation-owned properties will be exempt and some will not. If the property may be exempt, it only becomes exempt if the owner provides the appropriate notice of its exempt status to the tenants on or before August 1st, 2020, or in any lease initiated on or after July 1st. Then we look at duplexes. For the purposes of the statute, a duplex is qualified as your standard duplex where you have two side-by-side units on one parcel, or you have a single-family residence with a permitted accessory dwelling unit. So the residence with the accessory dwelling unit would also qualify as a duplex under this law. They are exempt as long as an owner lives in one of the units, and as long as the owner claims the exemption by issuing the appropriate notice to the tenant. Other exemptions include buildings that are less than 15 years old. Best question I got was from a long-term client who asked, his buildings are clearly more than 15 years old. He asked, what does he have to do for his buildings to become less than 15 years old? And I told him that probably wouldn't be worthwhile. You know, the new law isn't that restrictive. But I also heard from another attorney that there's a certain percentage of the structure that if you alter a certain percentage of your structure, then the county will let you claim that you are now a new building. So I could refer you to them if you're interested. New tenants are exempt from the rent cap. So anytime you have a brand new tenant in property, meaning that none of the people occupying the property have ever occupied that property before, you've got brand new tenants, you can increase the rent as much as you want, bring it up to fair market value. And there are also many other exemptions. So those are for exemptions. There is a similar notice that a non-exempt property has to issue, and the verbiage that you have to put in these notices is statutory. Now, I have a cheat sheet that I use, and I am very happy to share with you. In fact, I think this may be the free resource that we are going to send you after this webinar, that I just think this is a much better way to look at it, because if you read the statute, it'll put you right to sleep. So if the property is not exempt, then we have this rent cap that applies. And the rent cap is a simple part of the statute. The rent cap limits any increase in rent annually to a total of 5% plus cost of living, not to exceed 10%. What does that mean? It means that you can always increase it up to 5%, and then you have to look up an index that measures cost of living. There are lots of different cost of living indexes. The easiest one to find is CPI, the Consumer Price Index. I looked that up in June, and as of May, CPI for 12 months had increased 0.1%. That's very low, and it's because CPI has gone down significantly over the last 3 or 4 months. And also, landlords cannot increase the rent more than 2 times per year. Those two, if you do increase the rent 2 times per year, you add them together, you cannot exceed more than the 5% plus cost of living in 1 rolling year's time. There's a conservative way to look at this rent cap and an aggressive way to look at the rent cap. A conservative way would be to just stick to the 5% plus your index. A more aggressive landlord or attorney, particularly an attorney, who said to me that she felt that because of the ambiguity in the statute, she could always get the court to allow up to 10% because it's just unclear. And then maybe you go into court and you let the court knock back the rent. So I take the more conservative view, and I recommend that you just do 5% plus CPI. The harder part of the statute is this just cause eviction. So the just cause eviction applies only to non-exempt properties where the tenants have continuously and lawfully occupied the premises for more than 1 year. So at that point, once the tenant has been there more than 1 year, then the landlord must determine, before issuing any kind of notice to the tenant to try to terminate the tenancy, whether it's an at-fault or a no-fault eviction. An at-fault eviction includes the tenant's breach of the lease, and it would not require relocation assistance, whereas the no-fault eviction, where the tenant is not causing their own eviction, does require the landlord to pay 1 month of relocation assistance, 1 month of rent. At fault includes non-payment of rent, tenants who are causing a nuisance, criminal activity, refusal to allow entry to the landlord, failure to renew a lease when the landlord has offered one, and a breach of any other material term of a lease. Our no-fault evictions require the payment of relocation assistance and include, you have to have one of these for no-fault eviction, that the owner will occupy the premises, or the owner is withdrawing the premises from the rental market, or the owner is performing substantial remodeling, or the landlord must comply with a government order that requires the tenants to vacate the premises. So these no-fault evictions are a little bit harder to make them valid. And so then, let's see. Once you've claimed your exemption or your non-exemption, if you're not exempt, you determine whether you're at fault or no-fault eviction, and then you issue your notice accordingly. The new statute also provides that when you're using a 3-day notice to terminate a tenancy, you now have to do 2 notices. So for not exempt properties, 2 notices are required. One is the initial notice notifying the tenant of their breach. Some of these notices provide the right to cure, other kinds do not provide the right to cure. Let's say it's a 3-day notice to pay rent or quit. The tenant has 3 days to cure the breach by paying the rent. And then under the statute, the landlord has to issue another 3-day notice to terminate the tenancy. That second notice does not need to provide an additional period of time to cure, but it is required before the landlord can proceed to terminate the tenancy, establish unlawful detainer, and evict the tenant. And then finally, if it is a no-fault eviction, there are 2 ways that the landlord can pay the relocation assistance, and they have to opt for one or the other in the notice. They can either prepare a check or payment to the tenant within 15 days of the termination of the tenancy, or they can waive the final month of rent. Now, these rules sunset on January 1st, 2030, and you may be wondering why they made these rules in the first place and why they're making things so difficult on landlords. It's because of the housing crisis in California. The lack of affordable housing prompted the legislature to do this, and maybe if our housing situation has gotten any better by 2030, they may allow these to just expire. Let's hope so. So then the next subject matter is the San Diego Tenants' Right to Know Ordinance. This is one that people often miss. San Diego Municipal Code was created, this 98.0701 through 0760, back in 2004, and it applies to rental units in the city of San Diego. There are certain exemptions which include institutional facilities, government agencies, owner-occupied residences, single resident occupancy hotels, SROs, hotels, and mobile homes. It also only applies to tenants who have been in the property for 2 or more years. So you get 2 years to try out your tenant. If it's not working out, you want to get them out. If you're in the city of San Diego, you want to get them out before the 2 years limitation hits, because otherwise you have to have one of the following 9 reasons in order to evict your tenant. And this applies to whether you're doing a 3-day notice, a 30-day notice, or a 60-day notice. We'll talk about 30 versus 60-day notices next. But the 9 reasons to evict under the City of San Diego ordinance is: number 1, non-payment of rent; number 2, violation of an obligation of the tenancy except the obligation to surrender possession at the end of your lease term, unless the tenant has been presented with a new lease and failed to agree to it; number 3, causing a nuisance. And this statute specifically defines nuisance, different from our California law nuisance. It's causing an unreasonable interference with the comfort, safety, or enjoyment of any of the other residents in the housing complex. Number 4 is illegal use of the premises. Number 5 is refusal to renew the lease when a new lease is presented to the tenant. Number 6 is refusal to provide access to the landlord or their agents. Number 7 is the correction of violations. So if a landlord obtains all of the necessary permits from the City of San Diego to perform substantial repairs or improvements on the property, particularly to correct violations, and then seeks to recover possession for the necessary repair or construction, when the removal of the tenant is reasonably necessary to accomplish the repair or construction work, then this may be a reason to evict the tenant. So that's a tough one to meet. Number 8 is withdrawal of the residential rental structure from the rental market. That may happen upon the sale of a property. Number 9 is the owner or relative is taking occupancy. So occupancy by a spouse, parent, grandparent, brother or sister, child or grandchild. The child or grandchild could be by blood or adoption, or a residential manager who plans to occupy the rental unit as their principal residence. That's an interesting little exception. So the notice to the tenant to terminate the tenancy must set forth one of these 9 reasons in order to effectively be used in the eviction of the tenant. Otherwise, the tenant has a defense to their eviction. 30 and 60-day notices. This is about 5 years ago, the state of California provided a new amendment to the statute that provides for 30-day notices to residential tenants. And it says that once a tenant has resided in the premises for more than 1 year, actually it says 1 year or more, which means that on day 365, the tenant transitions to this 60-day notice. So once the tenant has been there for 1 year or more, the landlord must use a 60-day notice if the tenant is not in breach of their contract. So if the tenant's in breach of the lease, you'd use a 3-day notice. But for these no-fault evictions, you would use a 30-day notice for the first year, and then you'd have to use a 60-day notice after the first year. We also recommend that regardless of AB 1482, even if you're exempt from AB 1482, even if you're not in the city of San Diego, it's important to put a reason in your notice. And that's because it helps the landlord to avoid claims by tenants of retaliation and discrimination. It's a very common defense by the tenant to say, the landlord's retaliating against me because I complained about the condition of the property. But if the landlord puts in their notice that the reason for the eviction is because they want to move into the property, then that would suffice to do away with any of these other defenses by the tenant. All the landlord has to show is one legitimate reason why they need to evict the tenant, and they can move forward and overcome the tenant's defense. The exception to the 60-day notice requirement, and I know of only one, is California Civil Code 1946.1d provides when the unit is being sold to a bona fide purchaser at fair market value, and the landlord is under contract with the bona fide purchaser to sell the property, fair market value is what the buyer is going to pay. And so long as the escrow has not been open for more than 120 days, and so long as a 60-day notice has not already been issued, the purchaser also has to intend to reside in the property for at least 1 year, and the purchaser has to act in good faith. If all of these elements can be met, then the landlord, the seller, can use the 30-day notice instead of the 60-day notice, even if that tenant has been there for more than a year. So it's often hard to use this during an escrow because escrows don't last long enough to evict tenants. So the buyer really has to be on board and really needs to want that property in order to exercise this exception. All right, so then we've got a plethora of COVID-19 issues. These are all novel problems that haven't been litigated. The results, when and if they are litigated, would be very unpredictable, but we will see many of these kinds of cases that I'll tell you about, many of these issues coming through the courts. First of all, we expect to see an increase in bankruptcies, an increase in foreclosures, which means there will be an uptick of litigation issues coming and in cases coming out of the bankruptcy courts. We will also find a lot of use for the homeowner's bill of rights as the foreclosures start taking place. We would expect to see a lot of deference to tenants in the courts and a preference for keeping people in their homes, particularly people who are claiming that they have a hardship related to COVID. And so it's tough to predict what other lawsuits may arise from the novel situations that we're seeing. Many tenants will be particularly sensitive to exposure and people coming into their homes. They'll be adamant about staying in their homes and quarantining, even if the landlord needs to get in to make repairs, even if the landlord wants the tenant to be out so that the landlord can show the property for sale. Tenants will probably cannot be expected to leave for these purposes. It's also important to maintain a high degree of concern for the safety and liability if someone gets sick. So if you go into someone's home and then they end up getting sick, it's possible that the landlord or their agent could be blamed for bringing the illness into the home. It's also important to prevent your employees and your agents from getting sick. So you need to provide whatever they need, the masks and gloves, and also let them know what they should be doing in order to prevent themselves from getting sick. Other tenant concerns include whether any residents in the building are sick. So if the tenant asks the landlord, do you know if anybody in our building has COVID? What's the landlord to do? We recommend that a landlord should always make medical privacy the priority. If the landlord discloses private medical information, they could be liable. If they disclose false medical information, they could be liable for defamation. And so keep it to yourself unless, I mean, you also can't lie about it. If somebody is asking, like we've got the DA's process servers being used as researchers for tracking down COVID cases. and they have reached out to landlords to ask them about private information about their tenants and what is the landlord supposed to do. Well, if they have no orders from the court, then you should keep private information to yourself. Or if they do have documentation showing that you should be disclosing information, take it to your attorney first and make sure it's okay for you to disclose the information that you have. So be very careful about asking people for private medical information as well. Similar to people with disabilities, you never know what kind of liability you might incur if you ask the wrong question or ask it the wrong way. So you want to talk to your attorney if you feel that you need to start asking some of these questions about people being sick. Tenants are concerned about whether landlords are doing an adequate job of cleaning. So the recommendation about cleaning common areas is to document the procedure, to use a third party to perform the cleaning so that you have witnesses and you have documentation supporting that you are meeting reasonable standards for cleaning. Notify occupants about restrictions such as please wear masks in our elevator, please wear masks in the hallways, so that they understand that they're in closed spaces and that they're supposed to be wearing masks there. You could have a guard during high traffic areas enforcing your rules, and you could also provide your staff. You need to provide your staff with the supplies they need so that they can stay healthy as well, such as masks and gloves. Entering into residential units is very sensitive. I mentioned this a little bit before, but the procedure that we recommend, and we have a form that we're happy to share, is when you post a written 24-hour notice of entry, the standard statutory notice requires you to state when you're entering, who you're bringing, and what's the reason for your entry. And there are only a certain number of authorized reasons under the statute why you are entitled to enter with 24-hour written notice. At the bottom of our form, we provide a tenant authorization so that they can sign off stating, yes, I authorize this entry. And that should resolve some of the liability issues if they authorize the entry. It also provides space for them to identify any issues that may be going on. Like if somebody is sick in their unit, they can disclose that. If they want to make sure you're going to wear masks and gloves and take off your shoes, they can put that on the form before they sign it. So, it's just important to have a dialogue with the tenant before just going into the unit. Okay, so there are different levels of necessity for entry, such as repairs needing to be made to mold, where the tenant can't move out in order for the repairs to be made. Another interesting issue was someone smoking inside the unit, and I've pointed this out before, that someone who's a smoker can't smoke while wearing a mask. And also a lot of apartment buildings have designated a group smoking area. So going to that group smoking area and smoking without a mask on is a recipe for disaster, because people can't necessarily social distance in that area and they're not wearing their mask. So it might be a good idea to allow someone to smoke in their unit if they're concerned about that. Showing the home to potential new tenants or potential buyers, that has a plethora of other issues, and the realtors have their own forms for dealing with those kinds of entries. So it may be best to use a professional who's trained about how to show property in the current environment. Okay, so then commercial tenant concerns are really very different from residential concerns. And a lot of the stuff I've covered goes for both residential and commercial, but you can tell certain issues like entry into the premises are a bit more sensitive for residential than for commercial. Commercial tenants are worried about, their business is shut down, they're not making enough money to pay the rent. What are they going to do? Can they get out of their lease? Can they renegotiate with the landlord? Is the landlord going to cut them a break? Many leases have force majeure clauses, and the force majeure clauses may or may not have appropriate language in them dealing with pandemic or dealing with acts of God. But usually the force majeure goes in favor of the landlord and prevents the tenant from voiding or breaking the lease because of a pandemic or an act of God or some other unforeseen thing. California Civil Code provides for a contract to be terminated if there is some superhuman force or by operation of law, the contract cannot be completed. And this gets us to this other issue, a common law issue called commercial frustration of purpose. And that, I think, is where we're going to see the most interesting cases, where if there's no force majeure clause on point and the tenant claims commercial frustration of purpose and their business has been significantly impacted, they may win this kind of argument. But the key to this, that I learned from a CLE course that I took recently, is that the tenant has to vacate. As long as they're still in the premises and they haven't completely vacated, they're still using the premises. And so the case law requires the tenant to vacate. But these are unique circumstances, and so we may see some new case law coming down the pike. Renegotiating leases, there are a lot of interesting ways that you can change your lease in order to provide for a better situation for the landlord and the tenant. You could also use virtual mediation to help renegotiate the lease. There's a bunch of legislation coming down, but I'm running over time, so I want to leave time for question and answer. So I'm going to leave off the legislation, and if somebody really wants to know something specific about one of the ones that I'm familiar with, I'd be happy to talk about it. But we'll open it up for Q&A. And so, do we have anything?
We don't have anything in the chat right now, but if anybody has any questions for Shanna, feel free to unmute yourself, and we are happy. We've got about 10 more minutes, and then we'll go from there.
If nobody jumps in, then I can just go over the legislation.
Let's do that.
Okay, I'll stop the screen share at this point. And oh, now I can see everybody who's on. Okay, great. So jump in if you have any questions. I'll just review. We've got AB 828. This is the statute, the legislation that was proposing reduction of 25% of the rent for tenants who have a COVID-related hardship. And the way that it's set up, and by the way, I'm oversimplifying this because there's a lot more in this legislation than just this, but this was what was making the news. The proposal to allow a judge to reduce the rent by 25%, the 25% has been removed from the statute. So now it's a judicial remedy where if the court finds that the landlord has 10 or more units, or if they have less than 10 units, that it would not be a hardship, the judge can award possession of the premises after an eviction, during an eviction, can award possession of the premises to the non-paying tenant if the court finds they have the COVID-related hardship, and then issue an order to the tenant to start paying the monthly rent plus 10% of the past due amount. So it basically sets up a 10-month payment plan by court order. And if the tenant fails to make the payment, the landlord can go in fairly quickly to court, does not have to start the case all over again, but can go back in and submit a declaration to the court that the tenant has failed to abide by the payment plan, and then get their writ of possession fairly quickly. So this statute has turned from, in my opinion, it went very tenant-friendly, and now it is somewhat landlord-friendly because it does provide the landlord with a way to deal with the COVID hardship if the tenant just isn't paying. Then we have SB 939, and this one is currently in suspension. It's under submission in a committee, so it's not looking good for this one, but I was interested in this because it would provide not only some relief for non-judicial foreclosure, but also for commercial tenants. It would provide for the commercial tenants to negotiate new terms of the lease with the landlord. And if the tenant and landlord cannot reach an agreement, then the commercial tenant could void their lease. A lot of commercial tenants would love to be able to void their lease, and they just don't know what to do, and it's just a very difficult situation for them. So this legislation would have saved a lot of them, but also it was predicted that something like this would push a lot of landlords into bankruptcy. And we are certainly getting a number of calls relating to landlords who are suffering financially from everything that's going on. AB 1436 is one of the newer pieces of legislation, and it does seem to be working its way favorably through. It has already gone through the Assembly, and now it's into the Senate. It restricts the use of security deposits. Initially, the first part of it is about how a landlord can or cannot use the security deposit for tenants who are not paying rent due to COVID. It also would deem the residential tenant to not be in default for non-payment of rent for up to 12 months while they have a COVID-related hardship. So if this one passes, it's going to be very helpful to residential units, dwellings. So those are the ones that I'm really up on right now, and there's a lot more to all of them. I'm oversimplifying them. I also want to point out that none of them have passed. None of these things I just mentioned are the law just yet, but we will likely see some of these coming down soon. So, okay, well, that's all I got for you guys today.